Africa Union threat to pull out its members from the Rome Statute over the Kenya case continues to cause a political and legal dilemma between the International Criminal Court and Africa's regional bloc. Samogina now reports on a battle that is taking shape even as the ICC is expected to play a pivotal role in the possible creation of a war crimes court.
Regional geopolitics and international law are at loggerheads overshadowing the Hague trials of Deputy President William Ruto. The trials of Kenya's leaders has renewed pressure on the ICC from the Africa Union. The continental body pushing for the excusal of the two top leaders from attending all trial sessions, but the ICC warns that the AU has gotten its approach wrong.
The ICC presidency has no authority to direct the judges to decide on the topics in this direction or another direction. It's for the judges who are seized with the case, so for the trial judges to decide on the hearing schedule.
The AU protest letter has been copied to 49 Africa heads of states, maybe to prepare ground for a mass withdrawal of the states from the Rome Statute. 34 of African nations are state parties to the International Criminal Court. Observers quip an en masse withdrawal of African nations will be catastrophic for the War Crimes Court.
It's going to, I think, break up the ICC as a court. There's no doubt about that.
Nonetheless, the War Crimes Court has once repulsed the AU pressure to refer the cases to Kenya. ICC President stated the court does not factor in political resolutions from regional outfits to inform its decisions. While the ICC projects itself as an independent international judiciary to wipe out impunity, the AU is playing hardball. The regional bloc retreating into political maneuvers to blackmail its members to find breathing space from the court sessions.
A letter to the presidency is not a request submitted to the trial chamber. It's not in accordance with our rules. So this matter is not brought before the trial chamber. So we cannot have a decision on that.
If as the trial or as an appeals chamber, they start then taking into account political considerations or negotiating politically with states parties in terms of their desires, where will that stop?
Experts view the AU mission tactful to pile pressure on the Hague Court to arbitrate on its concerns quickly.
What will be interesting is whether the court can also do so to states parties, because states parties have a status before the Rome Statute. They are the owners of the arrangement of the Rome Statute. So if they seek to participate in this way, what is the liberty of the court to say no to them?
The prosecutor has appealed against the excusal of Deputy President William Ruto from attending all court sessions. With mounting pressure, focus now shifts to the appeals chamber that faces a delicate balancing act on ruling on the merits of the law and being well alive to the political ramifications. Samogina, KTN.